Assalamualaikum and salam sejahtera. My name is Nur Aina Najwa binti Mazlan. I'm a 3-year student of Diploma in Quantity Surveying at UTM Space. Today I would like to present about a variation. During the carrying out of the work, it may become necessary to vary the work and condition under which work is carried out. Recall that most construction contracts are lump sum contract and that the contractor has landed a price for the whole work. If later there are variations to the work, varying the provision of the original contract, the party will have to negotiate them as a separate contract. To avoid this situation, standard from content variation clause. Variations refer to the scope of work originally specified in the contract, whether by way of an addition, omission, or substitution to the work, or through a change to the manner in which the work are to be carried out. In variation, DCA has the power to issue instruction which may constitute variation that entitle the contractor to additional time or the money. As to instructing and valuing variations, the form provides for the CA to instruct the contractor to carry out and the QS to value the work done. Variations refer to a change or modification of design, quality, and the quantity. In PWD, we refer to clause 24, while in a PAM, we refer to clause 11. Variations in PAM is the same with the variations in PWD. The architect may issue an AI ordering a variation or sanctioning any variation made by the contractor. No variation ordered by the architect or subsequently sanctioned by him shall vitiate the contract. Pending the variation of the variation, the contractor should carry out with a due diligence and expedition all variations so instructed. For the example, a plan shows that contractor must construct 2 windows in a room, and the specification do not specifically refer to any hinge on those windows. Supplying the hinge will be found to be part of the scope, as the work which is indispensably necessary for the completion of that work. Contract often also provide that the such work is not variation or is work which the contractor is required to perform under the contract. The example of cases that relate with this variation is Rock Advertising Ltd versus MWB Business Exchange Centres. Rock Advertising was the license of service office premise in the London. The license states that all variations to this license must be agreed, set out in writing and signed on behalf of both parties before they take effect. A list of sum £20,000 accrued and Rock orally agreed with an employee of MWB a payment plan to clear its debt. Unfortunately for Rock, however, that the employee was overruled by the someone more senior who evicted Rock and then sued for the arrears. Rock defended the claim and counterclaim for wrongful exclusion, relying upon the oral agreement to enter into the payment plan. MWB's position was the term of the license agreement was such that the oral agreement to vary the contract term was invalid. At first, instead, in the Central London Country Court, Judge Moloney QC found in favour of MWB that the decision was overturned by the Court of Appeal, which followed its previous division in Globe Motors. The Supreme Court decision decide was the principle of party autonomy operate up until the point that the contract is formed, but thereafter the contractual provision take a priority and effectively define the limits of party autonomy. Therefore, if a contract make a provision for variations, then the variation can of course be made but only in a manner compliant with the original contract term. It will be open the parties to vary a no oral modification clause, but in order to be valid, that variation itself have to be in writing. Then we have a change. Change also known as a variation order. It is a written order to the contractor, signed by the owner of the building project, and is usually issued after the execution of the contract to authorize a change in the work of adjustment in the contract or the contract sum. It is a mainly related change that are generated by anticipated causes. In an industry term, for an amendment to a construction contract that changed the contractor's scope of work, most change or modified the work required by the contract document, which in turn usually increase the contract price or adjust the amount of time the contractor has to complete the work or both of it. For there to be a valid change order, the owner and the contractor must both agree and all the term. For the example of change order is include the owner desire to move the location of wall to accommodate some other design element, adding a window where there was none in the original plan, or changing the finish of the floor from tile to a terrazzo. Then, what is a quantum merit and when is a quantum merit used in a variation? A quantum merit is the determination of a reasonable value of the work performed or service rendered. This is a typical claim where there is no formal contract or valid agreement between the parties. This Latin word quantum merit means as much as he deserves. In the Section 71 of the Contract Act 1915 allows a claim essentially based on a quantum merit. The name of a legal action brought a recovered compensation for work done and labor performed where no price has been agreed. When is a quantum merit used in a variation? Firstly, when the contract does not include a price for the work performed. Secondly, the initial work does not include the work you have been performed. Thirdly, the contract no longer exists because the contract becomes unenforceable because it is void, voidable, or frustrated. Then, either party has terminated the contract. However, some work has already been performed. And lastly, if you perform the work under a head of agreement rather than a contract. Lastly, it is example of cases that relate with a quantum merit, which is a Scott versus Pettison. The fact, so far as a material where the defendant by a prior agreement engaged the planter to work as a farm labor at a weekly wage for 1 year, commencing 5 days after the date when the agreement was made. That of course was a contract within the statute and should have been in writing in order to be enforceable, but is never put into writing. The plaintiff completed the year engagement and brought the action for which is illegal to be due to him under the express agreement. The court held that he could not sue for the wage themselves on the express agreement by the reason of the statute, but went on the whole to that nevertheless he could sue on the implied contract to pay him accordingly to his desert. In other words, that is would be a question for the jury as to what was a reasonable remuneration. It is submitted here that he vowed not to have been allowed to sue on this implied contract when the work was done under express contract, which was unrest since that. The ordinary principle under which a man can sue on an implied contract to pay him a reasonable remuneration, that is, on a quantum merit, will seem to be well settled. Firstly, if the work has not been done under express contract at all, then it is quite clearly that he can sue if he can prove an implied contract. That is, a contract proved by the acceptance of service for which a reasonable man would expect to be required to pay. This is a proposition requiring no illustration. Secondly, if the work has been done under express contract, then it is only in very special class of that he can sue on an implied contract, and the principle of those cases is that he can only sue on an implied contract if the express contract. That's all from me. Thank you.